Good morning, Your Honors. The consolidated matter before this court this morning are the cases entitled In Re Hinesburg Act 250 Permit, docket number 2016-273, and In Re Hinesburg Hannaford Site Plan Approval, docket number 2016-274. Representing the appellants, Mary Beth Bowman et al., is Alan Keyes. Seated at counsel table with Mr. Keyes is James Dumont. Representing the cross appellee, Agent of Natural Resources, is Kyle Landis Marinello. Representing the appellee and cross appellant, Martin's Foods of South Burlington, is Christopher Roy. Representing the cross appellant, Town of Hinesburg, is David Rue.
Good morning. Before we get started on the Hinesburg case, I understand that our Dean and President, Mr. Mahaly, has an introduction, and I want to say a word or two.
May it please the court?
It will.
I am Mark Mahaly. I simply want to express our extreme pleasure at the court being here. More and more experiential learning is at the heart of our education, and we can only do so much with simulation. So reality, bringing reality to the school it's essential. It's absolutely essential. And so we thank you for taking the trouble and putting the energy into picking the cases and bringing yourselves and your staff here. And really appreciate your being here. Thank you very much.
So you wouldn't be happy if we were holograms?
No.
Thank you. And let me thank VLS for hosting us. This, as you know, is an annual event, and we always look forward to it and hope that we can bring some interesting cases and some great advocates to the school. I know this is as big an audience as I've seen here. I appreciate your all coming and attending. I hope this will be interesting and informative to you, even though I do understand there were some class assignments that bring you here. So thank you all for coming. It's great to see such a large group of folks at one of our hearings. So I think it's for you to start, Mr. Keyes.
Thank you. May it please the court. The Hinesburg neighbors' fundamental objection to this project goes to its scale. It's too big for the lot, and it's too big for the town. And I think all the issues we've raised, which we may not get to all of them, we certainly won't get to all of them today, relate in one way or another to this fundamental concern. It's just too big. It's too big for the lot and too big for the town. The building setback limit issue is one illustration of that. The original subdivision approved plans that was submitted by the developer, the same owner that is an applicant here, contained a building setback limit, which is shown on these exhibits that I've blown up here. They're also in the printed case. There's a key showing all the different things that are shown on this map, but each of the lots has a little dotted line in the middle of it, and if you key it out to what it's referred to, it refers to building setback limit. The judge said that wasn't a condition of the approval, and we disagree.
So I'm confused about, are there two different setbacks? There's the setback from the waterways and then also a setback from the lot line?
The distances are different,
Right.
and they're shown here. You can see, for example, this is lot 15. Here's where the canal is, and the distance from the canal to the dotted line is greater than to the other lot lines. But it's all keyed as building setback limit. Now, as I said, this came from...
Now, we're looking at the map of the approval of this subdivision from whatever, 20 years ago or something.
Yeah, what we didn't get on, there were two photocopies, but here's the stamp, signed by the Planning Commission, approved. And the project, as approved, was shown on the 7 maps. This is the approved project. The developer, or let me just preface this, the Wagner case kind of illustrates all the points that I want to make here. In the Wagner case, the developer showed a wavy line that was labeled tree line, or that had various words describing a tree line. And then it showed some houses on it. And it says, these are for illustration purposes only. When a
But as I recall Wagner, and seems to be the main difference from the environmental judge's opinion, is there was also text that referenced the tree line as having significance
There was-
in terms of where you could develop, and here there's no text at all.
There's no text. In Wagner, though, the text was on the map. You had to look to the map to find the text. You didn't have to look at the decision.
But of
that-
course, the trial judge here said that finding the condition was critical to the issuance of the permit was diminished by the 75-foot setback condition had been amended or altered for at least 3 of the existing developments in the Commerce Park subdivision, including development within a year of the original Act 250 permit back in 1989. So it doesn't seem to have been a major component or requirement.
We say first that the meaning of the building setback limit is plain on the face of the exhibit. But if you're going to interpret it and look at outside evidence, for example, I guess what we're talking about, contemporaneous interpretation, which as the judge seems to be saying, you'd also look at other evidence. And we have other evidence that is more persuasive. And the standard of review is that you're reviewing this de novo. It's a condition that's part of the site plan, and it's a condition that effectively is part of the ordinance. So you're just determining, what does this mean? If you're looking outside the map itself, we say it's more persuasive for you to look at what this developer did contemporaneously in the Act 250 proceeding, when the developer submitted a narrative that said, there's a 75-foot setback line from the stream. What does this mean? It's a 75-foot setback line. The fact that the setback line was not enforced is not an interpretation, we argue. We cite a case where the court said non-enforcement is not interpretation. It's just non-enforcement. These were uncontested applications where they violated it, and you can't find an intent from a mere non-enforcement. You have to find an intent from some kind of interpretation. The Act 250 narrative informs what is meant by this line if you need some additional information. What the judge did, I think, was say, it's ambiguous, therefore it's void. But that's not your law. If it's ambiguous, if it's an ambiguous statute, you have to interpret it, and you have to use all reasonable means. In the Wagner case, there was testimony from the author of the tree limit, and from that testimony, you determined the intent of the line. The idea that something can be void for vagueness, I would say vagueness is different from ambiguity. Ambiguity means there's a meaning, there are alternate reasonable meanings, and you may have to look to other sources. Vagueness means there's no meaning. No meaning can be ascertained.
What's the alternate reasonable meaning here?
Well, I frankly don't know. It says setback limit. There's hardly any confusion about the word limit. And in the Willowell case, you said there might be confusion about building envelope or agricultural easement or other terms, but a speed limit is not confusing. Building setback limit, given an ordinance that talks about setbacks, is not confusing. So I don't think you have to go outside the record, but if you do, and it's your determination from the undisputed facts, is it more likely because it wasn't enforced that it wasn't meant to be a setback limit, given that the developer at the time proposed the same setback limit in the Act 250 case and explained we're keeping all our projects 75 feet from the...
But that just, according to the facts as found by the trial court, he says that the projects, enforcement of the 75-foot setback here would be inequitable. Numerous other developments within Commerce Park have not been held to the setback, some encroaching within 30 feet of Patrick Brook, and this one comes to within 65 feet of the canal. So isn't it a balancing of looking at what was planned in 1989 and what's actually happening in land development?
The violations are not, you can't excuse a new violation on the grounds that someone overlooked.
But I think the court's not looking at them as violations, looking at them as how to interpret this 30-year-old, 40-year-old initial subdivision plat.
Well, I asked the court in its de novo review of the meaning of this setback limitation not to consider uncontested approvals that happen to violate a setback in another portion of the subdivision. There was never any violation of the canal.
I saw that use of the wording uncontested in your brief, but I presume that each one of these developments had to go through site plan review. And so to the extent there was a proceeding, it was in the sense a contested proceeding between the town of Hinesburg and anybody who wanted to use one of these lots. So the town of Hinesburg must have known, or don't we presume it would have known, about what its prior approval had been for the overall area, and approved it. Isn't that an indication that the town of Hinesburg did not think there was a violation?
Well, I'm not sure you can make those assumptions. You might presume them, but as of finding the facts, what is more likely is that it may have just been overlooked. It wasn't thought about, and it was stipulated that these were uncontested.
Well,
And
you
again-
mean, like this is contested with the neighbors,
Yeah.
but still required an
Yeah,
approval
still,
by
yes, there was an approval, but we don't think it's strongly probative of the meaning of the setback. What meaning do you give the setback? I guess the idea is maybe that from failure to enforce, it's selective enforcement, or it's inequitable enforcement, but that the issue here really is it a limitation that's still part of the site plan? You just can't waive it.
Now procedurally, if we agree with you, what do you think should happen here? Can't they return to the local level and seek to get that waived?
Yes, they'd have to. They can't get it amended in the environmental court. They'd have to start over in the local level to get a new permit. And maybe they will reconfigure it so it's within the 75 feet. We don't know. But it has to go all the way back to the Development Review Board.
Is there a mechanism for them to seek an amendment to the original site plan so that they could keep the layout that they have, but then become
Yeah,
compliant?
the Rule 34 in Act 250 has been adopted essentially in zoning matters. So if they show it was either not critical or that circumstances have changed, they can get an amendment. So they would but the environmental court has no jurisdiction because that argument hasn't been presented to it. I'd like to turn to the Act 250 case and the canal path, criteria 9K. The judge, as an essential component of his findings, said the impact on this path was foreseeable, therefore it wasn't protected under 9K. And we think this is strictly a legal question of the interpretation of the statute. Is foreseeability a factor, or is it not a factor? If it's not a factor, we need a remand to go back and tell the judge to decide whether there was an impact or not, and how great that impact was, regardless of whether it was foreseeable.
But the logic, as I understand it, of the trial court decision is that Lot 15 is the last undeveloped lot within this subdivision. It can be developed commercially and industrially, and some of the various uses around there are like that. And therefore, when the town comes along and puts the path there, it's subject to the development of Lot 15 and can't be the reason for saying that the public investment is somehow impaired or the use of it is somehow impaired. What's wrong with that analysis?
Well, the judge over and over again said he was relying on the foreseeability. And-
Which is just another way of
Well-
saying it's a commercial lot in a subdivision.
Well, but we never contended that we didn't know this was a commercial lot. Our evidence was Mrs. Morgante, the select person who developed this west sidewalk said, we knew there were this is a commercial subdivision, and the commercial subdivision is a small-scale businesses. We expected everything to be looking kind of like it already was, and that our problem was not that it was commercial, but again, the scale.
But except that Lot 15, and that's very apparent from the map, is twice the size of any of the other ones, or more. So it's going to be a bigger development, right?
That may be, but it's still, once the public builds a facility, they're protected against material interference. To say they're protected against interference only if it's unforeseeable adds a term to the statute that isn't there. It would be a terrible precedent for the court to say the public's right to enjoyment and use only relates to unforeseeable development. The testimony showed that there was development of a grocery store that could accommodate the path and fit on this lot more appropriately than the one that was filled to the gills with retaining walls and parking lot and a 36,000 square foot store. So repeatedly the judge said, and then he went ahead and defined what foreseeable meant, and it comes out of thin air. In the sort of a parallel case, the Munson case, where I think it was one of the connector highways around Burlington, which hasn't been built yet, the state came in and said, well, you've got to build your project so it's compatible with our future use. And he said, future development is not part of the statute. And by the same token here, when we put it in, we don't have to be compatible with the future private use. It tilts the policy of 9K way too in favor of development to say, on the one hand, a private developer can build without regard to future public use, but a public developer has to take all future private development into account. The language isn't in the statute.
Can I just, I don't know whether you can see the time, and I'm not sure. The timekeeper tried to raise something, and because of the maps, it's a little confusing here.
You're approaching 15 minutes of your total
Okay.
time, sir.
Okay.
Well then, let me just make one brief comment on the issue of small scale, the requirement in the Act 250 narrative that referred to small scale projects. And that is, read the whole statement. The very tail end of it refers to appropriate to the local scale of development. The Act 250 application was for a project that's appropriate to the local scale of development. And in the Tyler case, the self-storage case, there was an ordinance provision that's very similar to that. Compatible village scale commercial uses. Those aren't ambiguous or void. Those are conditions that can be enforced. And where they appear, whether it's in the narrative or not in the narrative, doesn't matter. If the developer can reasonably ascertain, and this is again the same developer who submitted these words, he didn't say these words are for illustrative purposes only or not to be binding. They deliberately put it in an application, appropriate to the local scale of development. We think that should be enforced as well. And I reserve our time for others and other issues. Thank you.
I'm going to, if I may, Your Honors, lower these so I don't run afoul of the time cards. I've been known to do that. May it please the court, my name is Chris Roy and I represent Hannaford with respect to these two appeals. And while there are a lot of issues, I think they all revolve around the central question of whether Vermont's land use laws encourage smart growth in village centers or whether they can be used as a blunderbuss to shoot down infill development in a commercial park as part of a war of attrition. This project goes back to before 2010. We find ourselves before this court in 2017 with respect to development of a lot in a commercial park in a village center. Development, by the way, that isn't a cookie cutter Hannaford,
The applicant had charrettes, worked with the community. As a resident of Wilson, I'm jealous. We had a cookie cutter Hannaford. They're getting a nice custom Hannaford with a whole different design. And the real question here is whether it's even possible to develop in a city center. And it goes back to the question of, if we focus on neighbor impacts with respect to smart growth and infill development, at the end of the day, all that does is encourage growth out where there are no neighbors to impact. And that's exactly contrary to that fundamental policy.
I understand your political and land use argument. We've got a series of very specific permitting conditions, and the question is, are they compliant or not? Even if we think this is the best smart development in the world, don't we still have to enforce the laws on the
Absolutely.
books?
And I'll move right on to the Act 250 appeal. The first issue that was raised by appellants related to the canal sidewalk, and they have suggested that the court somehow below elevated the concept of foreseeability to a new element of criterion 9K analysis. In fact, that's not it at all. What you have is a statute or criterion that says a project cannot unnecessarily or unreasonably endanger the public investment or materially jeopardize or interfere with the public's use or enjoyment of the facility. If the trial court is going to determine the materiality of the interference, it has to consider the nature of the public investment. A trail along the rim of the Grand Canyon, even if it costs the same as a sidewalk between a road and a commercial park, is a very different investment, and the materiality of the interference is very different. Part of that goes to what was the context within which the investment was made. Here, the investment was made pursuant to an easement granted by the owner of the commercial park, and it is expressly subject to the rights to put utilities and access across the easement and the right to develop Lot 15. By the way, I would note for the record, we'd included the wrong deed as part of the supplemental printed case, and I've provided the clerk with the proper pages, and I've circulated that to the other parties. This is pages 114 to 117 of the supplemental printed case, which is Exhibit 84. And that exhibit, which is the easement deed, makes it clear that this sidewalk is subject to the right to develop Lot 15. It's also further worth noting that the town never sought an Act 250 permit amendment for the sidewalk, even though it's on property subject to Act 250 jurisdiction. So if they were going to claim that it somehow prevented certain kinds of otherwise lawful development.
Let me, because this crosses into the questions that were coming about the seeming violations or argued violations of the subdivision permit with respect to setbacks. So you've raised this, and you raised it in the brief. Tom didn't seek any kind of Act 250 modification. It's in the subdivision area. It's subject to Act 250 jurisdiction. What do we take from that? That this is nobody cares about this, or the violation has already occurred, and therefore any violation can occur? I'm not sure that I understand the argument on this.
Well, it goes to the selective invocation of environmental laws to oppose certain projects but not get approval for others. And this is a commercial park that has been going along swimmingly for 30 years. We have lots that have merged with buildings straddling the marked building envelopes. We have buildings that have been built closer to the actual brook as opposed to an industrial canal. We have a sidewalk that's been built without Act 250 approval. But it was all done in a way that indicated this is all consistent with the original intent of what was going on with this commercial park in our village center.
Is there any evidence, though, that anybody raised the setback issue when any of this was going on?
Not expressly, other than the fact that you had the original subdivision approval and you had subsequent site plan applications that showed development outside those building envelopes. And that raises the site plan appeal. And before I jump over to that, I do want to address very briefly the concept of the small scale narrative. That appeared in 1987 in a 3-paragraph section of the application entitled General Description. And the subdivision was designed first as a commercial industrial park, so somehow to suggest it's a place with quaint shops, selling their fares to local town folk and lucky tourists. It's a commercial industrial park. And then the language is intended for primarily local small scale. So even there, This is aspirational language, and as this court has dealt with any number of times, aspirational language does not rise to the level of certitude necessary to impose a specific condition.
Doesn't the use of the word primary suggest that some of it may be not small scale?
Exactly. And so that, our point is, there's no evidence suggesting that after this particular 36,000 square foot grocery store is developed, that Commerce Park still won't be primarily small scale. There are a number of, or local businesses, you have a number of them of varying sizes, varying architectural styles, and varying businesses throughout Commerce Park, and that's not going to change with the development of this particular project. Going to the site plan issue that Your Honor raised, with respect to the building setback, a couple things are worth noting. There were 18 numbered conditions in the original subdivision approval. Not one of them dealt with building setbacks. In addition, there were lot-specific site plans of the constituent lots within Commerce Park. None of them listed building setbacks. And there's no indication on the face of this that the building setback wasn't demarked just as a general sense of this is where we think the buildings will go, as opposed to an affirmative obligation expressly, as was the case in Wagner, as Your Honor pointed out, emphasized as a permit term. The Willowell decision deals with this, and as it happens to be, Judge Walsh, who considered this, was the trial judge affirmed in Willowell, and Willowell was issued after our trial and before the court's decision. So he obviously was familiar with Willowell and its impacts and employed that case in order to find that this was not sufficiently clear in order to qualify as a permit condition that can be resurrected some 30 years later for the first time.
It's hard for me to understand why, if those were just sort of conceptual markings, why you would make a key and draw the outline and use the term setback, which is a term of art that we understand to mean something that's legally binding, not a conceptual drawing. I mean, I'm not sure how you...
I'm not saying that one could not reasonably reach the conclusion that if you look at the general plan in isolation and you don't look at the rest of it, that one might consider that to be possibly a setback violation. But that's not the standard that applies here. This is, of course, on appeal from the trial court. The trial court evaluated the context and all of the surrounding facts, including the permit itself, and as well as the site plans and general plan, and reached the conclusion after trial that it was not intended and isn't enforceable as a precise setback
So
condition.
you don't think we're reviewing the threshold question of whether there's any ambiguity in this plan, you don't think we're reviewing that de novo?
Whether there's ambiguity is a de novo question. But if there is ambiguity and my client's reading is reasonable, which we think it is, given the circumstances that happened shortly thereafter, then the rule applies that these permit terms and conditions have to be construed in favor of the landowner, similar to zoning ordinances and the like. I would like now to address the issue we raised on our cross appeal, which has to do with the trial court's requirement that a traffic signal be installed down Route 116 a bit from the project at the intersection with Mechanicsville Road. Currently, Route 116, especially during the afternoon peak hour, has backed up traffic from Charlotte Road heading north past Commerce Street towards CVU. Over time, the town has had an opportunity to review that. In the evidence was a corridor study prepared by the Regional Planning Commission in which all of the corridor was evaluated and what should be done to improve the situation. And of the 12 priority projects identified by the town, not a single one involved improvements to the Mechanicsville Road intersection. This applies to both.
Now, I take it, and we don't have a map of that, so let me see if I've got this right. I mean, I do, I think in the printed case I have one, but not on display. I take it what's happening is people coming down Mechanicsville Road can't get on to 116 because of the traffic flow there, or if they do, there's a serious issue of whether they're going to cause an accident or not. And they're coming down from CVU because at the same peak in which people are either going or coming to work and whatever, and the CVU traffic is all coming to this place at the exact same time. And the result is, in that time, you have a level of service of F.
Right. Well, CVU, there is on CVU Road, ironically enough, and there is a direct access in CVU Road to Route 116. As you proceed down Mechanicsville Road, there then is the intersection with Commerce Street, which is a signalized intersection. So again, if somebody wants to make a left turn during the afternoon peak hour, they have a signalized intersection there. The difficulty arises if you instead go to the end of Mechanicsville Road and there's bumper-to-bumper traffic back to Mechanicsville Road. Fortunately, in Vermont, we have the practice of people letting folks in because they figure I'm already in queue, it's not really going to hurt to let somebody in. And there are any number of reasons why the town may not want a fourth traffic signal during that stretch. However, it's important to note that nowhere is there finding that this is a question of safety. High crafts locations in the area have diminished over time. This intersection of all of the intersections along the corridor is the safest of all of the intersections. So there are any number of reasons why a town may not want to have this issue, or this improvement done. There's an interesting interplay between Criterion 5 and the site plan standard. Under Criterion 5, you can't deny, you can only impose reasonable conditions. However, the burden of persuasion lies with the opponent, and congestion as well as safety is relevant. Under site plan, you can deny, it doesn't shift the burden. However, the only issue involved is safety. Importantly, there is absolutely no finding of safety being
Now, if I
harmed.
understand you face two decisions that are against you. They're based on a common core of fact, which is the analysis in the Regional Planning Commission study of the corridor. And as you say, one of them is you have an argument that you can't stop the development because of this. That's Act 250. But on the site plan one, your problem is that if it is upheld, it does stop the development because it can be a reason for a denial. Is that right?
Yes.
But your point is, because the standards are different, you have to address these separately.
Well, and because there is congestion, there's no question about that.
You are currently into 13 minutes.
Okay, excellent. There's currently congestion, and there's no doubt about that, and that's relevant under Criterion 5. However, there was absolutely no evidence and no finding by the court that any unsafe situation is being created by way of this project. In fact, the court found that the comprehensive suite of improvements, including Commerce Street, intersection improvements, sidewalks, signal phasing, truck traffic limitations, actually will improve the safety of the Route 116 corridor. So to the contrary, it's actually going to be safer after this project and its traffic improvements.
No, you're talking about the corridor writ large. Is there anything about the suite of measures that you proposed and that have been approved that addresses the marginal increase in the congestion at the Mechanicsville Road intersection?
There are improvements to sidewalks. There are phasing of signals along the corridor, which will do a better job of regulating traffic. And the improvements at Commerce Street will hopefully divert more traffic to go that way as opposed to Mechanicsville Road. However, it's not going to change the volume of traffic, which is an ongoing issue there. And the only way
And in fact, it's going to increase it, even if marginally.
It will marginally increase it. Now, most of the traffic, I mean, you're not going to go out from, it's rush hour, I think I'll go to the grocery store now. It's usually going to be, you're on your way home, you stop in at the grocery store to get stuff for supper, and then you go back out. But there will be some marginal increase in traffic.
I was confused by the trial court, and I did not read, thank goodness, the entire trial transcript here. But in his motion for the decision on the motion for reconsideration, he says the traffic signal was the only offered mitigation for the existing and projected traffic conditions. So if I go back to the original decision in printed case 94, I see that you proposed A through I of things to do to, that's Dickinson's traffic impact analysis. So part of it was, lengthening the left turn lane, installing sidewalks, and deliveries of vehicles will be limited in certain ways. And then phasing and extending the green light on Route 16 and Charlottesville Road intersection, the Shelburne Falls Road intersection, blah, blah, blah. And then finally, signals at Route 16 Commerce Street and Route 16 Charlotte Road have exclusive pedestrian phase. Throughout this whole thing, you did offer a $25,000 project impact fee to be used for signalization at the Mechanicsville Road Route 116 intersection. But were you saying you needed that?
No.
No, I didn't think so. So,
I think what the court was saying is we were offering no mitigation with respect to the physical intersection between Mechanicsville Road and Route 116. And we think you need to take a broader corridor view of the street network in its entirety. And we do think, not only do we think that we provided a lot of mitigation, the court actually affirmatively found that we did alleviate congestion, improve safety. I do want to.
and the Department of Transportation didn't say boo about it.
That's correct.
Okay.
I now will turn it over to the
Okay.
town's attorney.
Good morning, Your Honors. May it please the court. I'm David Rue, attorney for the town of Hinesburg. The town's principal concerns in this appeal relate to traffic and appropriate mitigation.
Your cross-appeal focuses on the court's dropping of the requirement that applicant perform post-development traffic analysis as a condition?
That's correct. That's correct.
Who opposes that?
I'm sorry?
Who opposes that?
No party has opposed that. Hannaford's expert agreed with the town in the local review process that its predictive traffic analysis at the Commerce Street Route 116 intersection may not play out in actuality as predicted, such that after construction of the project, a condition should be imposed to evaluate how that intersection functions.
Which intersection? The Commerce Street?
Commerce Street intersection. The issue there is one of geometry. The southbound left turn lane from Route 116 onto Commerce Street, which is primarily how most, I think, of the traffic will access the project. Just north of that intersection is a culvert over Patrick Brook on Route 116. The left turn lane length proposed there is 185 feet. If that's not sufficient and queues back up beyond 185 feet, that's going to clog the road network, prohibit vehicles from moving southbound on 116. And the applicant then, the appropriate mitigation there would be to lengthen the left turn lane, but that would interfere with the culvert, and the applicant would then have to widen the culvert and widen the roadway.
And the court pretty much said this is an enforcement action? Enforcement issue? If it doesn't work?
No, I don't
I'm
think
sorry.
so.
I've confused the intersections there. Go
Yeah,
ahead.
exactly.
But let's suppose that the post-development traffic review happens.
Yes.
And that it's not just a condition that the review happen, because something has to then happen in response. If the review shows that in fact the 185 feet isn't long enough for that left turn lane, is it a condition of the permit then that the road widening occur and the?
Well, if unreasonable conditions are shown after development, then we would go back to the district commission and appropriate mitigation would be considered, including widening the roadway, extending that left turn lane perhaps to 200 feet or 210 feet, depending on what's appropriate given the level of traffic at that intersection. And the applicant would then have to widen Route 116.
But that's essentially an amendment post-decision to the Act 250 permit, right? Opposing new requirements on them after the fact.
Well, it's a prospective condition to evaluate the impacts
I
of the project.
understand evaluation is a prospective condition, but the actual doing the road, which is where the money is here, isn't prospective.
Well, it was part of the condition that the DRB issued, right?
It was part of the DRB's permit. or the approval, and it was part of the court's original decision on the merits, that if the predictive traffic analysis was not correct, that we would have to be studied further, and perhaps the road would have to be widened in the future.
So if that happens, though, it's a prospective condition, but you can imagine all sorts of issues generating litigation around what is actually required on the basis of the traffic study. So are you then back in front of the DRB in a permitting frame, even though the permit has already issued, or is it an enforcement frame?
Well,
Or, I mean, which
this
doesn't-
sort of plays out best in Act 250 instead of at the local review process, because there you would go back to the district commission, yes, and it would rule on what the appropriate further mitigation would be, probably lengthening the turn lane and widening the road. At this point, the parties have generally agreed that such a condition is appropriate, and they're willing to go back to the drawing board if the predictive traffic analysis of the applicant is not correct.
Can you answer, so the other issue here is, we're talking about the study, but there's
Yes,
the traffic light.
exactly.
And-
That's- I
And
was
that's a
gonna get there.
condition that you pose as well. And what I'm trying to get my head around, we've seen a lot of Act 250 and zoning development cases, and almost all of them involve some condition involving a curb cut or lines painted on a road or stoplight. And it's never been an issue before as to whether the Agency of Transportation would actually approve those. How does that normally work? Is there some standard that there has to be plausibility that they will, or do they routinely get approved without any input from V-Trans?
I think usually V-Trans will agree if they're proposing to make changes at that intersection. The applicant didn't propose one, and the normal process is that a traffic signal warrant analysis be conducted first.
Before you get to
Before
these
you get there,
proceedings.
and that will determine whether a traffic signal is in fact warranted, given the congestion at that intersection. That warrant analysis also involves consideration of alternative mitigation measures.
So who would normally initiate that? Would that normally be the neighbors challenging the project, or would that normally be the proponent of the project trying to address the
I
mitigation?
think it's the proponent of the project first would come to V-Trans, or V-Trans itself or the town would say, we have a problem here, or we're proposing development that's going to impact this intersection. We need to do a traffic signal warrant analysis, and that did not happen here. Instead, the trial court simply imposed a condition of approval requiring a traffic study.
Yeah,
But they're requiring a traffic signal, excuse me.
Going back to your statement of what the normal method is, you can see the bind the trial court is in. The applicant hasn't draw in V-Trans. V-Trans hasn't come in. The study hasn't occurred. And so there's the trial court sitting there with a level of service of F on an intersection and nothing to improve the situation. In fact, it'll get worse because of some increase in traffic that comes out of the project. What does the trial court to do?
Well, the trial court doesn't necessarily have to do anything. It could be that
Yeah,
that level
well,
of
but
service.
it's got a level of F in the intersection.
But that's acceptable in a downtown village situation sometimes. And the other traffic improvements proposed may also mitigate that somewhat. I mean, this project is in the downtown village. It's not way outside. Some traffic in a village is acceptable.
But so let's assume, though, that the court found that the marginal increase in congestion was unacceptable and under Act 250. It may not be a reason to deny, but we have to
Yeah.
do mitigating measures. And the only evidence offered is a stoplight. And now we're hearing on appeal all these great ideas about traffic circles and other things, but nobody's actually brought that evidence forward. Is the developer stuck with their own failure to bring a lesser alternative to the court?
I mean, there is an option of doing nothing. I mean, that's a possibility here. You have an alternative. It's offered that you impose it was offered as evidence that a traffic signal was warranted. There was competing evidence that no signal is appropriate. And the court made its decision, chose to go with the traffic signal, but it didn't follow nobody followed the proper procedure to get there. And those that control the state highways were not even involved in this case.
But the town's not taking the position that nothing should be done.
At the very least, it should be studied further, and it was not. The
And you
town,
just said it's applicant's duty to start that study. They don't do it. Aren't they stuck with their inaction?
Or don't they run the risk of the court being persuaded that the evidence offered by the neighbors is more persuasive?
they do.
I mean, the trial judge here sent about as clear a signal as could be sent that he was getting backed into a corner.
Yes, he did. He did say that the only mitigation offered was a traffic signal, but he didn't necessarily have to impose that condition. I see them out of time, so I'm going to cede it, save it for
thank you.
rebuttal. Thank you.
Cross appellees and appellants have 14 minutes total.
Good morning, Your Honors. Kyle Landis-Marinella, representing the Natural Resources Board. The board would like this court to affirm the traffic signal condition at Mechanicsville at that intersection. And there are two reasons that this court should affirm that. First, the failure to preserve this issue below, in particular the functional or de facto veto argument. And it's undisputed that there is a lot of evidence below about the traffic signal condition. And when that's the case, it was incumbent upon Hannaford's and the town to bring it to the trial court's attention, this legal argument that they're raising on appeal about the functional or de facto veto. And that's an argument that has ramifications for really every Act 250 case. This would be another layer put on any time a trial court or district commissions before then are imposing traffic signal or any traffic conditions. This argument could be made.
I have a question. In the town's brief, it says V-Trans failed to raise the need for a traffic signal at this intersection in its comments on the project. Could you explain to me how those comments on the project are generated and what file they go in when they come in?
My understanding is that was at the district commission. It was before this matter went to the environmental court. And V-Trans is sometimes asked to participate
So
there.
apparently it was in this case.
I'm not sure if it was asked or if they did it on their own, and they did make comments, and the heart of the comments were essentially this was not a high priority, but something should be looked at here. And it is important. I think the town has asked that on a remand, V-Trans actually be made a party, but V-Trans has the authority to decide when it does or doesn't participate at the environmental court, and it makes that decision based on.
Is that right? So when you're talking about a light on a state highway, which can't go there unless V-Trans approves of it, they get to decide whether they're a party or not?
Yes, they do, Your Honor, and
The court can't simply say, look, this is about Route 16, a state highway, or 116, a state highway. You are not only interested, but you're an essential party here.
Well, I think that what the court's role is here, and I think it's important to step back, and the role was to make a finding on criterion 5 on the traffic issue. And here, the court did make a finding that this traffic signal was a necessary condition. And so there's a lot of talk about the study and whether that would be another way to do this. The court looked at that and decided, no, a traffic signal was actually needed to affirmatively meet criterion 5 here. And that does create another process that happens. They do have to go to V-Trans and seek approval. But I think what's really going on here is what Hannaford is proposing is just paying a portion of this, and they want V-Trans in so that V-Trans might agree to do it as part of their priority list. But if it's not part of their priority list, which it isn't here, then it's really incumbent on Hannaford's to pay for this upfront and then seek reimbursement
But the
afterwards.
state of the evidence was before the trial court is, even if Hannaford's paid entirely for it, there's no indication that the traffic light would actually occur.
That's speculative. I think that would have to wait until we see what V-Trans does. And I think at that point, there could be an opportunity to go back to the Environmental Division and say this condition can't be met. But we're a long ways from there now.
So what would the posture of that be? Would it be some sort of motion to amend the permit because the inability to secure the stoplight was unexpected change of circumstances that makes a change of the permit? appropriate?
Yes, Your Honor, I believe that is right. That would be the way that would happen. And again, I do want to respond quickly, though, to why the trial court landed where it did here. And I believe opposing counsel said something about nowhere is there a finding that this was a question of safety. And I have two responses to that. First, the trial court did not need to find it was a question of safety to impose a condition.
But you're here
under-
only on Act 250, right? I understand they're talking about, you have to find safety for site plan.
Well, criterion 5 includes both, and I actually think that they were looked at together here, and on PC 62, the trial court, this is the trial court's decision, the trial court did find that a signal at this intersection would, quote, reduce the need and opportunity for risky behavior, often accompanying long delays and frustrated drivers. And there was evidence in the record that this was the case. If you put a signal and you have signals on the other sides, you could coordinate them and you wouldn't have people pulling out in front of others.
Okay,
What was
Mr.
the evidence?
Marinello, your time is up, says our timer here. I take it this is only his time, or is that?
Only his time.
Okay, all right. So you're now eating up your colleague's time.
Yeah. I think I'll just conclude by saying that all this court is looking at this is whether the trial court had a reasonable basis for imposing this condition, and the trial court absolutely did, and therefore that condition should be affirmed.
Okay.
Thank you.
Appellants have 8 minutes remaining.
Thank you. I'll start with one of your initial comments about what's happening at this intersection. Yes, there was evidence that the people coming down Mechanicsville Road have to wait, and it creates a dangerous condition because the longer they wait, the more risks they're going to take. And
So was there evidence that was more specific, I mean, that sort of,
there were, the evidence was replete with safety issues. We had 2 traffic engineers, and they both discussed safety problems, but the specific safety problem at Mechanicsville Road in a stretch of high crash locations was the creeping into Route 116. There are rear end collisions, and that's exactly.
But the point of the cross appeal here is that there's no finding by the trial court of exactly the subject you're talking about.
Well, that was just quoted on page 62 of the Act 250 printed case. The judge said,
But
the safety-
it says installing a signal at Mechanicsville Route 16 intersection and coordinating it with the signals to the north and south will achieve a smoother and more consistent flow of traffic. Both appellants and applicants' experts agree coordinating traffic lights will improve congestion and reduce the need and opportunity for risky behavior, often accompanying long delays and frustrated drivers. So it's just road rage we're talking about.
we're talking about safety. Congestion and traffic and safety are like a Venn diagram. You can have congestion without unsafe conditions. I suppose you can have unsafe
You can
conditions
still
without.
have angry
but-
drivers.
Yeah, when you have, what he just said was risky behavior, and that's why you needed the light. And in the site plan case, Mr. Roy has cited where the court said all the mitigation, the suite of mitigation efforts the applicant proposed will satisfy the site safety criterion, but you've got to read the rest of that paragraph. This is on page 26 of the site plan printed case, which concludes, lastly, with the mitigation measures proposed and those we impose in the Act 250 decision, vehicular safety on site and adjacent streets will be ensured. So there's a safety finding in the site plan case. And certainly it's supported by the evidence. What they're complaining about is the judge didn't agree with their evidence. We have plenty of evidence about both congestion and safety. I want to go back briefly to the Justice Eaton's comment about what does primarily mean in the context of primarily local, small scale. And how I would read that is, as I said, read the whole sentence, which ends with appropriate local scale of development. And this is a condition that could be reworded as it's intended development will be appropriate local scale of development, primarily small scales, startup and such, so that it applies to the whole subdivision, that it's locally scaled. And
So why is having a supermarket not local scale? I mean, this is not something that's totally out of sorts in
not a car
communities
factory.
around.
In Hinesburg, we have a locally scaled supermarket called Lampman's. This is twice as big.
But it's not like an auto manufacturing plant.
Yeah, but the amount of traffic it's generating, the number of trips. It's bringing traffic from outside the town into the town. This is not a grocery store for the local needs of the community. It's large to feed on the traffic going to and from Burlington and from surrounding towns.
Doesn't that kind of go to Mr. Roy's point that that's what smart development theory is about? Because if you don't put it downtown and bring people into the town, then market forces are going to take it to the outskirts, and you're going to just be sprawling Hinesburg rather than keeping it concentrated in its core.
Well, it wasn't written into the proposal for the subdivision that this is intended for smart growth and large shopping centers to attract surrounding traffic are intended. Hinesburg doesn't want to be a Williston, but it doesn't want to be any bigger than it is. They intended this subdivision for local businesses. You can't just say you have to be local to be here, but locally scaled development is what it says. And so what never was addressed, because the judge said this is not a condition, and our evidence addressed is this project is too big for the site, and it's too big for the town. It's more than is needed. Lastly, I want to talk about the building setback limit and the idea that was stated that if it's ambiguous, the developer wins because it goes against private property rights. Well, our point, I hope you understand, is that if it's ambiguous, you interpret it. It's only when interpretation fails do you call it meaningless. Rules of construction are not positive law. The favorite article I have is on Carl Llewellyn on rules of construction. There's one for every occasion. You just don't say, oh, it's ambiguous, we toss up our hands. What you did in the Wagner case was bring in evidence and determine what it meant. And here we have the evidence of what it meant in terms of the developer's own proposal in the related Act 250 case. You have to go beyond the finding of ambiguity. You have to interpret. Thank you.
Cross appellants have 5 minutes remaining.
So do you object to the post-development traffic study as ordered by the DRB originally?
Originally, we didn't because we had offered to go along with that. When the initial decision was
And
issued...
you agree that it could order you to make further improvements based
Well-
on the evidence?
We agreed to the terms of the condition that were proposed. The opponents objected to that because they said it restricted their participatory rights to deal with amendments in the future and to raise issues in the future, which is creating the sort of open-ended future perpetual permitting that this court spoke about in Treetop. When that issue was raised by the opponents, we pointed out Treetop in a recent decision by the Environmental Court in Killington Village Master Plan decision that indicated you can't do that sort of post-development study. You grant it, and if it complies with what was represented, good. If it doesn't, you file an enforcement action. So we only raised it in response to the point that was made by the opponents. But on the record earlier, we were not objecting to it as originally phrased. Ultimately, the trial court, in thinking more about Treetop, decided, I'm just going to get rid of the post-development study. So we haven't appealed that issue, and we haven't spent time
But
briefing.
your argument would be not that it shouldn't happen, but that in light of Treetop, the mechanism for dealing with a finding that the 185 feet is not long enough would really live in the enforcement realm rather than some subsequent permitting process.
Correct.
Okay.
Now, I would like to very briefly mention the preservation issue that was raised by the state, or at least one arm of the state, of course. Agency of Transportation isn't participating, but the Natural Resources Board is. If they both were participating, I guess you would have had two attorneys general arguing. State versus Vermont, this court said that in order to preserve an issue on appeal, you must present the issue with specificity and clarity in a manner which gives the trial court a fair opportunity to rule on it. One need only look at the docket sheet in this matter to understand that every issue has been briefed to a painful level, and the trial court, as evidenced by its decisions on any number of pretrial motions, its decision on the merits and post-trial motions, had an opportunity to deal with all of these issues.
Let's not call it preservation, because that's a term of art that has to do with objecting or raising arguments in a certain way. You don't deny that you all didn't bring forward any evidence of a study, a corridor study showing the alternative mitigation at Mechanicsville Road, giving the court an alternative to deal with the congestion that the court found this would cause to the traffic light proposed by the neighbors.
We think the flaw in that analysis is looking at the transportation issue by arbitrary intersections taken in isolation. We presented expert testimony evaluating traffic along the corridor. The reference to language about signal phasing we are doing with all of the existing signals along there. And again, in the interest of trying to help, if the town and V-Trans decided in the relatively near future that they wanted to put a signal in there, we are willing to contribute $25,000 toward that effort. Not because it was required, but again, because we're trying to be a good neighbor in Hinesburg. The way this would normally happen is, okay, we're building a big project. You go to V-Trans of the town and say, okay, this is the traffic our guy says is going to be created. What should we do? And you go through all the mitigation, you design it, you get it approved by the folks who actually own the infrastructure. When you get a package that they're agreeable to, you present it as part of your application. Now, it is conceivable that there would be a circumstance where V-Trans wanted a signal light, and we said, we don't think you need one, and we're willing to take that up with the permitting authority. Then you would have a case where we're saying it's not needed, V-Trans would be there as owner of the infrastructure saying, we think it's needed, and then the court would be perfectly appropriate in ordering, we agree with V-Trans, you need to put a signal light here. You have a different circumstance here. The town didn't say that, said they want it. In fact, they don't want it. V-Trans didn't even participate. V-Trans had agreed that the suite of improvements we were presenting was adequate. The town's engineer agreed with all of our mitigation efforts. And so the court was left without authority to essentially impose the trial judge's will on the state agency that is charged with operation and maintenance of Vermont's highway infrastructure, dealing with alternatives, funding, timing, construction, design, right-of-way acquisition. In an adversarial permit proceeding, a court is simply not in a position to micromanage transportation policy in that manner.
So you're saying that under no circumstances could the court have done what it did? As long as V-Trans doesn't choose to participate, they can't ever order a traffic light, even if the evidence is overwhelming on that?
Unless the owner of the infrastructure is
And that's V-Trans.
subject to the jurisdiction, then I don't think that the court is able to do that. Thank you, Your Honors.
The next hearing for the court is scheduled for 11 this morning.
All rise. Is there your